Okay, it's 11 o'clock. So good morning, everyone. My name is Nina Gardner, and I'm an adjunct professor at the I-Law Department of SICE, teaching business and human rights. It's my distinct honor to moderate this webinar entitled A Landmark Year in the Law, covering the arguments made in the October-Fall 2019 term. We are very lucky to have as speaker our very own Professor Stephen Schneebaum, Interim Director of the International Law and Institutions program here at SICE and Practitioner-in-Residence, and this is very important, who has been teaching international law, EU law, as well as US con law in very high demand, may I say, since Trump was elected, and is a beloved adjunct professor at SICE for the last 30 years. He has coached very successful Jessup moot court teams for ages and even wrote 8 of the international Jessup international problems over the years. Professor Schneebaum is a practicing lawyer, now with his own firm, but was a litigator at prestigious firms like Patton Boggs for 25 years and started his legal career at the General Counsel's Office of USIA. His primary areas of experience include civil litigation before federal and local trial courts, public and private international law, antitrust and constitutional law, and over 50 oral arguments in 10 circuit courts of appeals and appellate or Supreme Courts of 6 states. So he knows his stuff, and including a number of death penalty cases, which he is still involved in to this day. He's been a member of the DC Bar since 1978 and a member of bars of nearly all the US Courts of Appeals and the US Supreme Court. He has also written a dizzying number of law review articles on human rights, international law, capital punishment, and I'm keeping this short because he has done so much. And for students here, it's interesting to see where he's got his education and how he started, right? So Professor Schneebaum has an extraordinary breadth of education. He started at Yale with a BA in magna cum laude in philosophy and a secondary concentration in math, which I have to say most people go into law because they can't do math, but he can do both. Then a master's in arts from Oberlin in philosophy. He studied philosophy at Rome University, went to Oxford to study jurisprudence, and obtained another master's in comparative law at George Washington University. In between all of this, he managed to translate 2 novels from Italian to English. Yes, he speaks fluent Italian, very good French, Spanish, and has, according to his CV, reading knowledge of German, Latin, ancient Greek, Hebrew, and Japanese. And I haven't been able to check, but somebody should. This is brilliant. As you can tell, we're in the presence of a very special person, dedicated to the practice and teaching of law, and an expert on today's topic. As you all know, we have 2 new conservative members appointed by President Trump to the Supreme Court, Neil Gorsuch and Brett Kavanaugh. This has been the Supreme Court's first full term since the arrival of Justice Kavanaugh, whose appointment, you may remember, was more than controversial. Professor Schneebaum will help elucidate some of the major rulings of this term with both new justices and tell us what to expect in the future. Professor Schneebaum will speak about 45 minutes. We'll be having about 30 minutes of Q&A. Please write your suggestions in the Q&A box and I will read them to our speaker. Just as a reminder, this webinar is being recorded, and should you wish to have the link afterwards, please contact Professor Schneebaum or SICE, the link you received, and it will be available upon request within a few days. And without any further tardiness here, we are going to turn to our very special Professor Schneebaum to hear about what to expect and what to understand from the Supreme Court from this last term.
Well, good morning, everyone, and thank you very much, Nina, for that very kind introduction. I want to plunge into this because we have a lot of ground to cover. This has been really a historic year. for the United States Supreme Court. It's a momentous year. It's a year that probably had the most consequential opinions of any Supreme Court term in this century. And there have been big cases, only a couple of which I'm going to be able to talk about today. There was a case, for example, that limited the scope of criminal public corruption prosecutions. Another one that concluded that states are free to punish presidential electors who fail to cast their votes for the candidates to whom they were pledged. Another decision held unconstitutional state laws that permit criminal convictions by less than unanimous verdicts, an opinion that may have consequences for death penalty litigation. And finally, a case that held on the last day of the term that much of the territory of the eastern part of the state of Oklahoma, including part of the city of Tulsa, is in fact Creek land and belongs to the sovereign Indian tribe. But what I want to talk about today are a couple of other areas in which I think the court has said very important things. These are about the separation of powers, about how to read statutory texts, about such cultural flashpoints as abortion and gay rights, and about the role of religion in the public square. Now, there are several overall lessons that I'm going to offer and that I hope I will be able to demonstrate are applicable based on the cases that I'll be discussing. But here are the conclusions at the beginning. First, Chief Justice John Roberts has shown himself to be a committed institutionalist. He is keenly focused on the need to preserve the dignity and the role of the Supreme Court. Second, the court has used the doctrine of stare decisis, and I'll explain more of that later, not only as a rule of decision, but as an important element in promoting public respect for the court itself, and particularly for its non-political image. Next, the conservative wing of the court has, I will argue, abandoned its traditional insistence on strict constructionism and has come out of the closet, so to speak, in terms of explaining its motives. Next, the court has been willing to declare that the president, whoever he or she might be, is not an emperor and is subject to the rule of law, but it is still extremely deferential to the powers of the president and seems unwilling to address at least some of the more obvious elements of presidential misconduct. And finally, the court has shown itself to be prepared during this term, more than in years, to accept religion as a justification for conduct that would otherwise be illegal. Now let me put meat on those bones. And the first two cases that I want to talk about are the ones concerning the subpoenas that were issued to President Donald Trump, the two cases called Trump v. Vance and Trump v. Mazars, USA. In the Vance case, Cyrus Vance is the district attorney for the New York County, that is to say for Manhattan, and he convened a grand jury and tasked it with investigating whether campaign finance laws were violated when Donald Trump, the presidential candidate, allegedly paid for the silence of two women who claimed that they had had affairs with him, and of course he denies those charges. The subpoena issued by the grand jury was directed not to the president, but to his accounting firm, Mazars, and it demanded the production of financial records, including tax returns, going back to 2011 for use in the grand jury, and therefore, of course, subject to typical rules of grand jury secrecy. This action was filed in state court. The president filed suit in federal court to challenge the subpoena, arguing that because he cannot be indicted for a crime while he is in office, he and his papers are absolutely immune from any kind of compulsory process, including at the state level. Two details are important before we get into anything more about this case. First, Mazars did not contest the subpoena, the president did. Mazars was perfectly willing to go along with it. And second, in raising his federal court objections to the subpoena, President Trump made no argument other than the argument that he was absolutely immune from process while he's a sitting president. He was unsuccessful in the trial court. He was unsuccessful in the US Court of Appeals for the Second Circuit in New York, and then the Supreme Court agreed to review the case. I'll come back to the conclusion in a moment. Meanwhile, in Trump v. Mazars, three congressional committees also subpoenaed personal financial information from the president, also from members of his family, and from various of his businesses. Again, he objected on the grounds of immunity, but he also stated in that case in Washington, D.C., that the subpoenas were not motivated by what he called a legitimate legislative purpose. They were essentially, in his view, a congressional fishing expedition. And again, the addressees of the subpoenas, the accounting firm, and in this case also the bank, Deutsche Bank, indicated willingness to comply if they were directed to do so by the courts. And again, as in the New York case, Trump's challenge was rejected at the trial court level, was rejected by the Court of Appeals, and the Supreme Court granted review. Now, the outcomes of the two cases differed substantially because the natures of the subpoenas differed substantially. In the Vance case, there was really very little doubt about the outcome. I don't think any regular observer of the Supreme Court had any hesitation in predicting that that subpoena would be upheld and the president's challenge to it would be rejected. The notion of absolute presidential immunity from judicial process has already been rejected by the court. In fact, starting in 1804 with Chief Justice Marshall, who allowed Aaron Burr, you all remember Aaron Burr from Hamilton, when Aaron Burr attempted to subpoena Thomas Jefferson to testify in his treason trial, Chief Justice Marshall held that Jefferson was amenable to service of process. And of course, in 1997, in Clinton v. Jones, President Clinton was compelled to attend a deposition, which of course ended up becoming the first domino in a whole series of dominoes that ultimately led to his impeachment. The claim that this case should be treated differently because state court process was involved rather than federal court was not an argument that the Supreme Court gave much credence to. Chief Justice Roberts wrote the opinion for the court, and he demonstrated in it that presidents have always been subject to judicial procedures, again, since the case of Aaron Burr, which the Chief Justice discusses at great length, to the more recent cases, not only of President Clinton, but of President Nixon before him, who was compelled to hand over documents that had been requested in a judicial proceeding when he again resisted compliance with the subpoena. The arguments that the president is too busy or that proceedings might be instituted to harass him or to impede his presidential authority, all of those arguments had been made in Nixon and in Clinton, and they were all rejected, and they were rejected here again. The court held that Thomas Jefferson, Richard Nixon, Bill Clinton, and Donald Trump all must comply with court orders. The vote in that case was 7-2, with Justices Gorsuch and Kavanaugh, the two Trump appointees, concurring in the judgment, but not in the opinion. Justices Thomas and Alito dissented. Justice Alito actually made the case for absolute immunity, despite all of that precedent. And Justice Thomas, who dissented here, interestingly, did not dissent in Clinton v. Jones. He was on the court during that term. The Vance case gave the Chief Justice the opportunity to provide a lesson in civics, and he took it. And this lesson, I would argue, should have been unnecessary. May we see the first slide, please?
Sure. Let me share the screen. Let me get to the next one.
There we are. So Chief Justice Roberts wrote, 200 years ago, a great jurist of our court, that was none other than John Marshall, established that no citizen, not even the president, is categorically above the common duty to produce evidence when called upon in a criminal proceeding. We reaffirm that principle today and hold that the president is neither absolutely immune from state criminal subpoenas seeking his private papers, nor entitled to a heightened standard of need. That's the civics lesson. At the end of his opinion, he wrote this: "The arguments presented here and in the Court of Appeals were limited to absolute immunity and heightened need. The Court of Appeals, however, has directed that the case be returned to the district court, where the president may raise further arguments as appropriate." Some commentators saw that and said, well, all right, all that the Chief Justice has done here is kick the case back to the lower courts, where the president will attempt to tie those courts up forever and never have to comply with the subpoena. But I think that's incorrect. And I say that for two reasons. First, because the lawsuit that President Trump filed in New York was focused only, relied only on the argument of absolute immunity. There is no other argument currently before the US District Court for the Southern District of New York. What's more, even if President Trump were to attempt to raise new arguments, perhaps objecting to the scope of the subpoena, or perhaps contesting the motivation of District Attorney Vance in seeking those records, he would have, I think, a hard time demonstrating to the federal court that there is a basis for federal jurisdiction. I suspect that when those arguments are presented to Judge Marrero in New York City, he will dismiss the case and tell the president that if he wishes to challenge the subpoena in state court, he's free to do so. But the arguments that he would raise, scope, motivation, are not ones that will cause the district court, this Supreme Court of New York State to tarry very long. So I suspect that that the state court will not allow this to be dragged on very much longer, and the records will, I think, be produced to a grand jury in Manhattan sooner than the media have been reporting. Now, that's, of course, not a guarantee that we will
have
ever.
a question. Before the November election is the...
I think so. I think so. But it's no guarantee that we will ever see those documents, of course, because they will be submitted to a grand jury, and
Right.
therefore they will be subject to the usual provisions of grand jury secrecy, which are taken very, very seriously. Now, the Mazars case had a different structure and therefore a different outcome. In the congressional subpoena case, the court focused not on the threat of abuse by a district attorney, but on the separation of powers issue. The court concerned itself with whether congressional subpoenas might actually impede or prevent the president from doing his job. And all of the justices appear to have shared that concern. Only Justices Alito and Thomas dissented. The other 7 justices joined in the majority opinion. Justice Thomas helpfully reminded all of us that if Congress ever has trouble with the president being difficult or recalcitrant, that they should just go ahead and impeach him. What an idea. Nobody else had thought of that. That said, the court essentially, in the Mazars case, declined to rule. The court sent the case back to the Court of Appeals for the District of Columbia Circuit with instructions to assess 4 things before deciding whether to enforce the subpoena. First, whether there any other source could provide Congress with the information that it needs. I submit that that's a distraction, because this subpoena was not directed to the president. It was directed to his accountants and his bank. So there was no possibility of disruption of presidential activities. And therefore the source that the Congress has sought, from whom it has sought the documents, is not the president. And therefore that criterion ought here to have been satisfied. The second has to do with breadth. The court asked, is the subpoena broader than is reasonably necessary to support Congress's legislative objective? A reasonable question, but it's a question that could have been decided on the papers. The papers that were presented to the Supreme Court included the defense by Congress, by the House of Representatives in particular, of the scope of its exercise that drove it to seek those papers from the President of the United States. It's hard to imagine how the record on that issue could be expanded when the case is sent back to the DC Circuit, but that's what the court decided to do. The third issue was whether Congress had adequately identified its legislative aims. Again, the papers themselves disclose the legislative aims. There was no reason to punt on that question. the Supreme Court could simply have decided it. And finally, the court asked, are the burdens on the president reasonable in the circumstances? And here, of course, there were no burdens because President Trump was not asked to do anything in order to comply with the subpoena. There was no burden on him, no interference with his activities, no interruption of his day, whether it's spent at the Resolute desk or on the golf course. So the court skipped out on this one. The lawyers representing the House of Representatives, and they're very good lawyers, insist that they can easily address these questions, and I think they can. I think they already have. And I'm not sure I understand why the liberal wing of the court was willing to go along with the idea that this case needed further development. This is an obvious win for the White House, an obvious win for President Trump. And so while the outcome of the two subpoena cases may be that the president must comply with judicial process just like anyone else, president is not above the law, et cetera, et cetera. But in reality, the role of the court in calling him out for perceived violations of the law is strictly limited. And the court has indicated it will not be lured into a tug of war between the political branches, that is, between the executive and the legislature. And that, I think, is too bad. There is an argument, indeed, that the court's action in the Mazars case really constitutes an abdication of its role. The next case I want to talk about is the abortion case that came down this term, the case of June Medical Services v. Russo. Now, to understand that case, we need a little bit of background to see how this case arose. Obviously, as everyone knows, it has been the law since Roe v. Wade in 1973 that a woman has a constitutional right to obtain an abortion, at least until the point of viability of the fetus that she's carrying. And since Planned Parenthood v. Casey in 1992, the Supreme Court has made it clear that the test that legislative enactments must pass or not in order to be constitutionally valid is that they not place an undue burden, those are the key words, an undue burden on that constitutional right. Now, of course, the right to an abortion is not mentioned in the Constitution, of course, and indeed the right to abortion is grounded, has always been grounded by the Supreme Court in the right to privacy, which is also not mentioned in the Constitution. But the court has held that where the Ninth Amendment to the Constitution says that rights not delegated to the federal government by the Constitution itself are retained by the people, and that the granting of certain rights or the reference to certain rights in the Bill of Rights should not be taken as disparaging others, the Supreme Court has found that there is a right to privacy, there is a right to be left alone, and that right is translated in many ways, but one of those is the right to an abortion and the right not to have that access unduly burdened. In 2016, just 4 years ago, the Supreme Court considered a case called Whole Woman's Health against Hellerstedt, a case from the state of Texas, in which a sharply divided court, a 5-4 court, held that Texas had imposed an undue burden and therefore an unconstitutional burden on women's right to have an abortion in the first trimester at least, by requiring that doctors performing abortions have admitting privileges in a local hospital. The Supreme Court said, you can't do that. That is an undue burden. The Louisiana statute that was at stake in June Medical Services was virtually identical to the Texas statute in Whole Woman's Health. There was only one reason why the Supreme Court agreed to take this case. It was totally controlled by the outcome of Whole Woman's Health. That reason is the retirement of Justice Anthony Kennedy.
I see.
And because Justice Kennedy is now replaced by Justice Kavanaugh, the feeling was that perhaps there would now be 5 justices willing to begin the process of dismantling Roe and Casey and all of the other cases the Supreme Court has ruled on over the years since 1973, establishing and defining the right to an abortion. The result of June medical services was shocking, literally shocking. The liberal wing of the court, the 4 justices on the left of the court, wrote, as they always do, that there is a constitutional right and it must be protected. The 4 on the other side wrote, as they always do, that there really is not a constitutional basis for this award. It's time to overturn these cases. Indeed, Justices Thomas and Gorsuch basically indicated that they were willing to start the process of dismantling Roe v. Wade right now. 4 votes to 4, with Chief Justice Roberts in the middle. And the Chief Justice himself had dissented in Whole Woman's Health. In Whole Woman's Health, he held that the Texas statute, identical to the Louisiana one, was not an unconstitutionally undue burden. It was perfectly all right, justified, not undue. If it imposed a burden, that's okay. But here, Chief Justice Roberts held that the doctrine of stare decisis governs. Stare decisis, as he wrote in his opinion, stare decisis instructs us to treat like cases alike. The result in this case, he said, is controlled by our decision 4 years ago invalidating a nearly identical Texas law. The Louisiana law burdens women seeking pre-viability abortions to the same extent as the Texas law, according to factual findings that are not clearly erroneous. For that reason, and he might have added for that reason only, I concur in the judgment of the court that the Louisiana law is unconstitutional. It's an interesting position for Chief Justice Roberts to take.
Yeah.
In the famous or notorious, depending on your point of view, case of Citizens United against the Federal Election Committee, Chief Justice Roberts wrote a concurring opinion. That is, of course, the case that allowed corporations to essentially engage in unlimited spending in political campaigns. The Chief Justice concurred in the overruling of Supreme Court precedent, and he wrote, and I'm quoting, "Stare decisis counsels deference to past mistakes, but provides no justification for making new ones." Why didn't he say that here? What motivated the Chief Justice suddenly to elevate the principle of stare decisis in a case that was, for all practical purposes, the opportunity to do what he has always been thought to want to do, which is to undo the decisions starting with Roe v. Wade. And obviously the Chief Justice's vote was against his conscience, but he saw, and I think he gets enormous credit for this, he saw that there was a more important issue at stake. And it was not, the issue was not simply the role of the court. It was not simply some abstract commitment to the idea of precedent or the idea of stare decisis. It was demonstrating to the American people that the Supreme Court of the United States is not a tool of the political branches. It's not just that the American people have come to rely on Roe and its progeny as the law for half a century. That's true, but that's not enough. In the Chief Justice's mind, I imagine, a 5-4 vote to begin the undoing of that line of precedent would have begun the dismantling of the respect for the court itself.
Yeah.
Now, in Bush v. Gore in 2000, Justice John Paul Stevens wrote in dissent, one of the 4 who would have ordered a recount of the votes in Florida, as I'm sure you all remember. Justice Stevens wrote, "We all know who the winner of today's decision is. It's George Bush, who's now going to be president of the United States. But we may not be clear on who the loser is." And he said, "I'll tell you who the loser is. The loser is this court, because from now on, we will need to undo the impression we are giving to the American people that we are doing the business of politics. We are legislating. We are no longer judges." Now, Justice Stevens may have been right in the long term, but he certainly was not right in the short term. In the short term, although respect for the court may have taken a bit of a dip in public opinion after 2000, That dip has certainly not been maintained, and the court is still the recipient of enormous respect and honor and veneration by the people of our country. I think that John Roberts saw that issue writ large in June Medical Services v. Russo, and the principle that he stood for here was that if there is going to be a shift of this radical, this significant, this far-reaching, it was not going to be by a 5-4 vote, and it was not going to be based on political alignment. That may give us, those of us who believe that this line of cases should be maintained, may derive some satisfaction from that. But I think we have to temper it a bit, because if the time comes, and it may come, that the court is filled with justices who are no longer supporters of the right to abortion, I suspect that the Chief Justice's resolve will wane. And indeed, of course, that may happen soon.
Yeah.
All right, that's the abortion case. Now, the next one I want to turn to is the gay rights case, Bostock against Clayton County, Georgia. And this really is a very interesting decision, not only for what it says, but for why it says it. It is a decision I suspect that will have very far-reaching consequences. Here's the context. Title VII of the Civil Rights Act of 1964 makes it, quote, I'm reading, an unlawful employment practice for an employer to discriminate against any individual with respect to his, and of course we would say today his or her, compensation, terms, conditions, or privileges of employment because of such individual's sex. Period. Quotations closed. Very simple, very straightforward. Sex discrimination in employment, and also not only in employment, but in public accommodation, in housing, and other things, is prohibited by federal law. Now, many people who studied the origins of this statute and its legislative history in 1964 point to the idea that originally the Civil Rights Act was conceived as a way of enforcing racial integration, particularly in the South. And the Southern Democrats in those days, who opposed that effort, were looking for ways of torpedoing the Civil Rights Bill so that it would never become law. And one way to do that, they thought, was sticking the word sex in there, because certainly that would break down the ideological barriers. That would make it possible for Northern members of Congress, Republicans and Democrats, to vote against the Civil Rights Bill, even though they might have been deep believers in racial integration, because they couldn't tolerate the idea of having employment and these other things open equally to the sexes. Well, obviously, if that was the motivation, it failed, because the statute was adopted and it has been implemented. And ever since then, ever since 1964, sex discrimination in employment has been prohibited nationally. Now, generally, when courts consider cases of discrimination, they ask one basic question, the but-for question. If someone comes to court and says, I was discriminated against at work because I'm Black, or because I'm a woman, or because I'm Jewish, or because I'm Hispanic, or whatever the reason might be, the courts will ask the plaintiff to demonstrate that but for that criterion, but for that characteristic, the outcome would have been different. I wouldn't have been discriminated against. I would have been promoted, or at least kept on board. So if that's the test, and the Supreme Court has endorsed that test many times, if that's the test, then the idea that discrimination based on sexual orientation is a subspecies of sex discrimination is too obvious even to need to be discussed. Look, if I am female and I have a picture on my desk at work of a very nice looking young man, and the boss comes into my office one day and said, who's that a picture of? And I, as a female person, respond, that's my husband. The boss will probably say, oh, wow, he's very nice looking. Isn't that wonderful? When did you get married, et cetera, et cetera. But if I, as a male, have that same picture on my desk, and the same boss comes into the same office and asks me the same question, and I say, that's my husband, it's lawful for him to say, pack up your desk, you're fired? That doesn't make sense. Obviously, sexual orientation discrimination fails the but-for test. And that's simply a matter of statutory interpretation. It's what the words say, applying the tests that the courts have engendered and developed and refined over the decades. The plaintiffs in this case were two gay men and a transgender woman. All of them claimed that they were fired from their jobs because they were, because of their sexual orientation, or because they didn't conform to standard sexual stereotypes, and therefore that their dismissals were, quote unquote, because of their sex. Justice Gorsuch wrote for the court, a conservative justice, a Trump appointee. Mm-hmm. Justice Gorsuch simply asked the question that I just asked, the but-for question. What would have happened to these people had they been of the opposite sex? And the answer, of course, was they would not have been fired. They would not have been dismissed. They would not have been penalized in any way. So that's that. But obviously that isn't that. There's more to this. And in particular, Justice Gorsuch addressed at great length the significance, if any, of the fact that in 1964, if anyone had tapped on the shoulder of the Congress members who were promoting and even proposing what became the Civil Rights Act and said, excuse me, sir or madam, but will the passage of this act actually protect against sexual orientation discrimination? They undoubtedly would have said, what are you talking about? Of course not. We don't do that. That's not about that. But to ask that question is to do precisely what the conservative wing of the court has always said we should never do, which is to say, to look outside the four corners of a statutory text that is not ambiguous. It doesn't admit of more than one meaning. It says specifically that discrimination based on sex and employment is illegal. So what difference does it make that Congress didn't use the word sexual orientation in 1964? Those words were probably not even in common vocabulary in 1964. Well, the idea that the words were missing from the statute, and that has significance, is an idea that Justice Scalia, right, the patron saint of strict constructionism, Justice Scalia said, obviously, Congress cannot express its will by a failure to legislate. And he said that an argument that would base meaning on what Congress did not say, and these are his words, should be laughed out of court. That was in a case in 1998 called In Re, the Estate of Romani. So what's happened? What's changed? How is it that the conservative wing of the court has suddenly abandoned this notion of strict constructionism, suddenly abandoned the idea that when Congress speaks, it speaks with words on paper that are published in the United States Code, but instead its motivation, its thoughts, its intentions somehow factor into the discussion. This isn't the first time, of course, that we've seen this. We saw it in Justice Scalia's own dissent in the landmark case of Obergefell v. Hodges in 2013, the case holding that there is a constitutional right of gay couples to obtain marriage licenses from states. But Justice Gorsuch pointed out that this isn't the first time or the only time in which the court has expanded the reach of the Civil Rights Act of 1964. The Civil Rights Act doesn't say anything about retaliation, for example, and yet the courts regularly apply the Civil Rights Act of 64 in support of plaintiffs who claim not that they were discriminated against necessarily, but that they were punished. They were discriminated against, not again based on their race, but based on the fact that they asserted a claim of discrimination based on race or sex or religion. Not only that, the Supreme Court held years ago, in 1998, in a case called Oncal against Sundowner Offshore Services, that sexual harassment is a subspecies of sex discrimination. The court wrote, sexual harassment is conceptually distinct from sex discrimination, but it can fall within Title VII's scope. Title VII is the Civil Rights Act with respect to employment. It can fall within its scope. So the horse is out of the barn. There's no point in calling the locksmith anymore. the statute is being read the way it was written, with the consequences that flow naturally from the words that Congress adopted. The dissenters didn't see it that way. The dissenters, the two, I think, most conservative justices on the court, Justice Alito and Justice Thomas, openly disregarded the strict constructionism that is traditionally assigned or identified with their political ideologies. They said that we need to look back to 1964. We need to understand that nobody would ever have thought that those words meant what they said. That's a very interesting argument with respect to the Civil Rights Act for several reasons, but one of them, just in a couple of sentences, is this. The Civil Rights Act itself was challenged on constitutional grounds almost immediately after it was passed. And the Supreme Court found that the Civil Rights Act of 1964 was a valid exercise of Congress's power to oversee interstate and foreign commerce. Now, is anybody going to make the argument that in 1787, when a group of wise men, many of whom were slave owners, wrote the Constitution of the United States, they would have contemplated for a single second that the assignment of the authority over interstate commerce to Congress would someday justify a statute that forbids race discrimination? I mean, it's impossible to make that argument. Now, Justice Alito just went down that road. Justice Kavanaugh took a different approach. Kavanaugh made the argument that, as he said, words have ordinary meanings alongside literal meanings. Now let's look back at what Justice Gorsuch said in the slide. Ours, he said, is a society of written laws. Judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations. In Title VII of the Civil Rights Act, Congress adopted broad language making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law. End of story. Justice Kavanaugh didn't say that. Justice Kavanaugh came up with a very curious dissenting opinion. He tried to argue that, he said, words have two kinds of meaning. In other words, he wasn't going to rely on intent. He was going to buy into the idea that we must look at the words of the statute. So far, so good. But he said words can have more than one meaning. Words have ordinary meanings and words have literal meanings. And he said, reading the Civil Rights Act literally would yield the majority opinion. But if we read words, he said, in their ordinary meaning, we come up with a different outcome. And how do we know that? How do we know that assigning an ordinary meaning to the word sex rather than a literal meaning would give us a different outcome? Well, we know that because we look back at 1964 and see what the drafters actually meant. In other words, he wanted to have it both ways. And it doesn't work that way. It doesn't work that way. The empirical analysis that he attempted to engage in is not consistent with strict constructionism. Now, I've got to point this quote out because I hope that some of the listeners to this webinar are former students of mine in the Jessup class, and they will remember that I always begin the semester by putting on the board the famous example, which I didn't invent. It comes from the great legal philosopher H.L.A. Hart. And I asked the students the question, how would we attempt to find out the meaning of the term, of the sign that reads, "No vehicles in the park"? What would we do? Would we ban tricycles? Would we ban suitcases on wheels? Would we ban wheelchairs? And Justice Kavanaugh said, in making his distinction between ordinary and literal meanings, he said, consider a sample. A statutory ban on vehicles in the park would literally encompass a baby stroller, he said, but no good judge would interpret the statute that way because the word vehicle in its ordinary meaning does not encompass baby strollers. I think that is utterly wrong. Of course, the word vehicle in its ordinary meaning encompasses baby strollers. If you look up the word in any dictionary, it will say a vehicle is a contrivance for the movement of persons or things from one place on the surface of the earth to another. That's a vehicle. Baby carriage is a vehicle, of course it is. The reason that that outcome would be rejected by good judges is not because they're disagreeing about the meaning of the word vehicle. It's because the consequence is absurd. The consequence of using that language, no vehicles in the park, to ban wheelchairs or baby strollers is so obviously inconsistent with other important values that infuse the whole statutory code that we can't accept it. That's why he's wrong to say that this is a matter of semantics. It isn't. It's a matter of meaning. It's a matter of context. And here, Justice Kavanaugh is using this so-called definitional issue as a justification, not for expanding rights, but for denying them. And fortunately, he failed in that effort. But I think this is important because now after Bostock, I think we can be fairly confident that the Chief Justice, as well as Justice Gorsuch, will now be confident appliers of and interpreters of the law as written. That's great. That's what we want. And we can perhaps we can anticipate a little bit of relief from the quadrennial drumbeat. We're going to hear it this fall. We hear it in every presidential campaign about candidates who are going to appoint judges who don't legislate from the bench. That's always been a nonsensical meme, meaning absolutely meaningless to lawyers, purely red meat for various kinds of political constituencies. That maybe we've heard the end of it because Justice Gorsuch and Chief Justice Roberts have now said, we're not legislating, we're just reading what the law says and applying it. Remember during his confirmation hearings when Chief Justice Roberts said, think of judges as umpires, no, just calling balls and strikes. Nobody goes to the ball game to watch the umpire. More power to you, Chief Justice. Let's hope that that view survives. Let me say a couple of brief things about religion, because we are running a bit out of time. Religion in 21st century America. There were 3 cases that addressed the question of religion in the public square. 2 of them were the big cases, and one was one that I think slipped under a lot of people's radar. The first of those is Espinoza v. Montana Department of Revenue. That was the case in which the state of Montana extended certain tax benefits to people who made donations to private schools. But it did not permit those deductions if the donations were to religious schools. So it made the distinction between secular private schools and sectarian private schools. And the court used to be, and that was challenged on constitutional grounds. The court used to be very rigorous in its approach to this issue. Indeed, there were times in the 1950s when the court even seriously questioned whether it was acceptable for the state to provide bus transportation to school kids attending religious schools, Catholic schools or parochial schools, finally concluding that they could as long as the purpose was secular and not sectarian. The court used to be rigorous about that, but here, Chief Justice Roberts wrote, a state need not subsidize public education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious. The Montana statute, therefore, the court held was unconstitutional and thrown out. And it might seem as this is a fairly innocuous, insignificant case, but I suggest that it is not. Justice Thomas, in his concurring opinion, put this as another brick in the wall, if you like, of those who, he called this a needless obstacle to individuals' attempts to vindicate their religious freedom. Who'd have thought that the Montana tax code was infringing people's religious freedom, but never mind. Justice Alito went further. Justice Alito said that this case was important to defend the rights of parents who, as he put it, believe that their local schools inculcate a worldview that is antithetical to what they teach at home. In other words, there's a right to public money to be taught a curriculum different from the one in the public schools on ideological grounds. That the court has never said before. And there's no question but that Espinoza will be used by states seeking new and more creative ways of providing benefits to parents who want to send their kids to parochial or other religious schools. The next case is Little Sisters of the Poor, Saints Peter and Paul Home against Pennsylvania. That's a case under the Affordable Care Act, the Obamacare statute, that says that, well, again, I suspect everyone knows, that ACA requires employers to provide health insurance to their employees, in most cases, including reproductive health coverage, but religious employers, religious institutions, for example, may opt out simply by filing a form indicating that they have a religious scruple against providing reproductive care. And if they file that form, then the employee receives that coverage, but from other sources, from public sources. And the Little Sisters of the Poor are a Catholic order of nuns who believe, among other things, that deliberately, and this is their words, deliberately avoiding reproduction through medical means is immoral. So they didn't have any hesitation about stating their objection to the use of their funds or any funds to provide reproductive care, birth control pills, for example, to female employees. They didn't object to that. They objected to filing the form. They said that by filing the form, they were dirtying their hands. They were corrupting themselves and somehow participating in the immorality of providing this kind of medical intervention. The case came before the court in a very complicated structure. It would take a long time to walk through it, and I won't do that. But bear in mind, this was not about abortion. It was only about contraceptive care. And the Supreme Court nevertheless said that it was permissible for the Little Sisters of the Poor, of course they made a fuss over that name, the Little Sisters of the Poor to remove themselves, to indemnify themselves against the statutory obligation to provide reproductive care, or even to complete the form explaining why they can't do that. Justice Ginsburg in her dissent pointed out that as a result, as many as 125,000 female American workers will lose part of their health insurance coverage because the court did not even limit itself to religious objections. It opened the door to what it called moral objections, allowing employers, and ever since the Hobby Lobby case, we know that that means corporate employers as well as individual employers may suddenly discover that they have scruples, they have religious or moral objections to providing reproductive care. And of course, the case isn't based on reproductive care. What happens if we're talking about a religious employer who disapproves of blood transfusions, or vaccinations for that matter, or treatment of COVID-19, for example? There is nothing in this decision that says that it is only with respect to reproductive activity that will permit employers from opting out of the relevant objections to Obamacare. The third case I'm going to talk about just very briefly is a case that, as I say, sailed under everybody's radar. Linda Greenhouse called it out in the New York Times. It's a case called South Bay United Pentecostal Church against Newsom. Newsom as in Governor Gavin Newsom of California. And in that case, which was not fully argued or fully briefed before the court, but presents a very troubling development, especially in the light of Espinoza and Little Sisters, and this came down before those two decisions. The state of California imposed a restriction similar to those in many states, requiring that public gatherings be limited to 25% of the capacity of the building, or a certain number of participants, whichever is less, and included religious services in that catchment. This was going to be throughout the duration of the pandemic. A church sought to enjoin the executive order on the grounds that it unduly burdened religion, that it was unconstitutional under the First Amendment. Chief Justice Roberts explained in his concurring opinion that the argument was nonsensical, that there was no comparison between churches where people sit perhaps for hours closely together in a room, breathing the same air. There's no comparison between that and what happens in, say, a restaurant where someone walks in or walks out, or a shop where you make your purchase and leave. The Chief Justice said simply the obvious difference between one kind of congregating and another kind of presence is so clear that the governor of California was well within his authority to distinguish them in this executive order. The kicker here is that 4 justices of the Supreme Court dissented. And the dissent was written by Justice Kavanaugh. And here is an excerpt from it. He said, in response to COVID-19, California has now limited attendance at religious worship services to 25% of building capacity or 100 attendees, whichever is lower. The basic constitutional problem is that comparable secular businesses are not subject to a 25% occupancy cap, including factories, offices, supermarkets, restaurants, retail stores, et cetera, and he added cannabis dispensaries. Why do you suppose he put that in there? That's to show the kinds of people that we're talking about here, the kinds of amorality that we're talking about here. In any event, it seems perfectly clear that his invocation and repetition of the word comparable, he uses it 8 times in 4 pages, is not applicable here. These activities are not comparable. But even more important, this is a factual determination. What in the world is a Supreme Court justice doing, making factual decisions? They wouldn't do it in Mazars. Why are they doing it here? And I suspect the reason is that religion has come to be a very much more significant presence in the public square with this court, even with Chief Justice Roberts acting as the moderator as he has been, than we have seen in decades and maybe ever. So those are the cases I wanted to review. I have some closing remarks, but I'll save them for the end in order to encourage some degree of participation. And I hope the Q&A box is filling up.
It is.
Good.
It is. So our first question, and keep them coming in because this is riveting. Thank you, Stephen. I think we have learned a lot about the individual justices and where they may be going, and some of these key issues like stare decisis and strict constructionism and how that may be changing. So thank you very much for those insights. Okay, our first question is from David Vanier. The question is that a friend?
He's a former student, a former Jessuper.
Wonderful, and there's another student queued up. So, as Congress is increasingly inefficient, it seems that SCOTUS is horse trading in a way that is usually expected to happen on the Hill. Chief Roberts seems to have taken over Congress's role to come to compromises. How dangerous is it for SCOTUS to fill in the void left by Congress? Also, every presidential election seems to confer additional powers to the executive branch. Is there a threshold at which point SCOTUS should start conferring greater power to the legislative branch? From reading the Constitution, it seems that the legislative branch was seen as the greater one, as it can fire the president or even the Chief Justice.
Okay. Well, thank you, David. It's nice to hear from you. It's been many years. The first part is really nothing new. The idea that the Chief Justice of the United States is the broker of compromises is something that goes way back. In fact, not only the Chief, all of the justices to some degree will play that role. When Justice Brennan was retiring from the court, Justice Brennan, one of the great liberal lions of the 20th century, an appointee of President Dwight Eisenhower, when Justice Brennan retired after 30 some odd years on the court, he was asked, what is the most, they have a sweetheart interview, to let the justice be sent out on a high. He was asked, what is the most important characteristic of a Supreme Court justice? And his answer, without batting an eye, was the ability to count to 5. Because 5 justices make a majority of the court. And so very, very frequently, a draft opinion will be circulated among the justices, and changes will be made, tweaks will be made, deletions, additions, in order to get that fifth vote. And we'll never know, of course, deliberately so, we'll never know exactly how that horse trading went, but it goes. And it's something that we have always accepted. And it isn't necessarily a bad idea, because after all, we do want the Supreme Court to vote by majority. And if that means that a decision has to be somewhat diluted or modified in order to bring on the fifth vote that forms the majority, well then, that's the law that the court has approved, and that's the law that future courts will apply. Now, as to the second point of David's question about the Supreme Court and power, the power of the Supreme Court to review legislation, of course, famously, is not in the Constitution. But the Constitution doesn't say that. But in Marbury v. Madison, 1804, Chief Justice Marshall held that it was implicit that without the power to decide that statutes did or did not conform to the Constitution, the court would be toothless. And so the court, of course, in Marbury v. Madison, threw out a section of the Judiciary Act of 1789 that provided jurisdiction for the Supreme Court that was inconsistent with what the Constitution said. Interestingly, after the Supreme Court tossed the section of the Judiciary Act in 1804, 1803, the court did not again hold a statute unconstitutional until 1850s, when it issued its horrible decision in Dred Scott v. Sanford, the case that ruled that it was consistent with the Constitution to treat certain human beings as if they were objects. So the court doesn't often use the power to declare statutes unconstitutional, but we sure want it to be able to do that. We do not, however, want the court to be weighing in otherwise, because if this is going to be a democratic culture, a democratic governance system, then we want laws to be made by Congress, as the Constitution provides, with the consent of the president or over his objection, as the Constitution provides. We don't have a system, as many countries do, whereby a piece of draft legislation can be submitted to the court for a determination of constitutionality before it's adopted. We don't do that. You gotta enact the statute. Somebody with standing, that is with skin in the game, has to be able to raise a constitutional objection, and that constitutional objection goes up. Sometimes those cases are easy. In fact, most times they're easy, but very often they're not, and that's why the Supreme Court is the Supreme Court.
Okay, we've got a question from a former student from both of ours, Sam Davidoff-Gore. His question is, how do the Supreme Court's rulings on religion align with international human rights understandings if religious freedom and freedom from religion? Yeah.
Well, okay, so as I think everyone knows, the Constitution, the First Amendment, has two provisions concerning religion, right? The Constitution both prohibits Congress from making laws that would establish a religion, and it also prohibits the adoption of laws that would abridge the free exercise of religion, and those are very different things. International law, to the extent that it addresses religious freedom at all, focuses on free exercise. That is, it focuses on the notion that people should not be persecuted, that criminal statutes shouldn't be adopted, that prohibit certain kinds of religious exercise. And obviously, as everyone knows, in the international context, there have been a lot of recent cases testing that. For example, cases concerning the wearing of Muslim headscarves in public places, cases in which the European Court of Human Rights has weighed in on cases both from Turkey and from France, coming perhaps to inconsistent outcomes, but that's a conversation for another day. As long as free exercise as such is respected, the idea that a religion is established is unlikely to raise any serious international concerns. There have been established religions in many democratic countries. Until recently, for example, the Queen of England was the defender of the faith, and apparently now will will, or at least either she or her successors will be the defenders of faith rather than the faith, meaning the Church of England. And there's no inconsistency there. As long as minority religions have free exercise, then international law is, I believe, generally satisfied. Do the kinds of threatened erosions of free exercise that are the subject matter of the cases that I discussed, do they rise to the level that they could be arguably seen as violations of international protections for freedom of religion? I really doubt it. I just don't think we're talking about anything that rises to that level of seriousness. And of course, the ultimate, forgive me, trump card is that the United States, although we are a party to the International Covenant on Civil and Political Rights that contains various kinds of protection for freedom of religion, we have decided that that treaty is not self-executing in the United States and therefore does not form the basis of enforceable rights.
Okay, so we have questions are pouring in. This is wonderful. There is no question we are going to be able to fill in the time.
Okay.
So we have a question from Tana Weiss. Do you see a conflict between the SCOTUS ruling on LGBT rights and religious liberties? And what steps do you think SCOTUS may take to attempt to resolve that conflict?
I'm really glad that that question was asked, and I'm sorry that I didn't stress that point earlier. There is a potential problem here. Justice Gorsuch, in his otherwise, at least to my way of thinking, very positive, encouraging, progressive decision, he did take note of the fact that there may be people who have religious objections that may be relevant in some way to the expanded reading of Title VII. Now, this is not a new story. We've had this come up before. In the Masterpiece Cake Shop case, just a couple of years ago, and this case certainly captured the public imagination, got enormous coverage in the mainstream media. A baker in Colorado was asked to make a cake, not to sell a cake, but to make a cake for a gay couple, a same-sex couple, who were planning to be married, which was perfectly consistent, of course, with Colorado law and with federal law. The baker declined because he said that creating a cake for that couple would indicate in some way his endorsement or acceptance of what he considered to be contrary to his religion or contrary to his moral code or both. Well, a lot of things about that case, because it had so much mainstream play, as always happens, a lot of the mainstream media coverage was simply flat out wrong. There was a big difference here between the baker selling a cake and making a cake. The Masterpiece Cake Shop said, we'll be perfectly happy to sell any of these cakes. Here's our display case. Pick one. We'll sell it to you for your gay wedding. We just won't make a cake for your gay wedding. And that raised freedom of speech issues and other kinds of complexities. But the other point that everyone missed, I think, or most commentators missed, is that this was not a case interpreting federal law. This was a case interpreting the human rights law of the state of Colorado. And the state of Colorado says that anybody who holds him or herself out as providing services to the public, including a retail establishment like a bake shop, or a retail service provider like a photographer, for example, or a florist, is obligated to do so without discrimination based on sex or specifically, explicitly, sexual orientation. So the question that actually was at stake in Colorado, in the Masterpiece Cake Shop, was whether that statute needed to have a carve out for some sort of religious excuse, and the Supreme Court ducked it. The Supreme Court was able to dodge it because the Colorado agency that handles equal employment or equal opportunity claims, forgive me, so badly garbled its process that the Supreme Court was able to say, well, this decision was clearly motivated by an antipathy toward religion. And given that, then we're not going to tolerate that kind of thing. Not necessarily a bad decision. A classic case, however, of hard cases make bad law. That case should never have gone to the Supreme Court. It will be that, or something like it will be back. And Justice Gorsuch has opened the door to that. And that is scary because I don't know whether any others on this call will be able to say what I'm about to say, but I am old enough to remember when people raised religious objections to racial integration. When people said the mixing of the races is forbidden by biblical texts, which they would trot out and read and justify racial bigotry on the basis of canonical texts. And today people do that with respect to sex discrimination in various religious areas. So if we are going to permit religious concerns to override the obligation to treat everyone equally, we are really opening the door to problems. Now again, Gorsuch did not say he was prepared to do that. He simply said that issue is not presented, and he was right. It was not presented in this case, but it's going to be presented, and it's going to be presented very soon, and that will be a case to watch very carefully.
That's very sobering. Our very own Professor Appleton is asking a very interesting question.
Which does.
So based on the recent decisions that you so ably reviewed, and I concur, how would you say the judicial philosophies of Clarence Thomas and Alito different from those of Gorsuch and Kavanaugh?
Yeah, that's a great question. Certainly, Alito and Thomas dissenting in the two subpoena cases suggests they're espousing a philosophy with respect to the structure of government that Kavanaugh and Gorsuch are not willing to espouse. That is an extraordinary level of deference to the executive, almost just describing the sort of unitary executive. Remember, we used to have those debates during the George W. Bush administration, where the executive is free to operate essentially without any compulsory process except what is in the Constitution specifically, meaning impeachment. So whenever the president can count on either there not being a majority of members of the House of Representatives who will impeach him, or that there will not be 2/3 of the United States Senate willing to take him out of office, if he can be competent of those things, then according to Justices Alito and Thomas, he's free to do what he pleases. The courts will not rein him in. Or if they will, it will be only in the narrowest of circumstances. And that's an outlier position. That's not a position I think that very many justices of the court historically would have adopted. Now, with respect to rights, I think that, which is a different issue, obviously, I think that Thomas and Alito are more closely aligned with Gorsuch and Kavanaugh. I think they do have a rather more restrictive view. They do have a narrower view of what is acceptable in terms of the exercise of rights. In particular, I think the four of them, plus the Chief Justice, have formed a pretty consistent majority in death penalty cases. As the four more liberal justices are increasingly, and Justice Breyer said this just the other day, as the four liberals begin to say publicly what I think they've always been saying privately, which is it's time to reevaluate the death penalty and to decide whether it really is constitutional under the Eighth Amendment. The five on the other side are a consistent supporters of the death penalty. So I think that they are of a piece generally. I mean, obviously each of the justices is different, and some particular issue might capture the attention of one of them or two of them or all of them for that matter. And I think it's hard, certainly hard based on the cases I've discussed, to be able to draw very much more by way of generalizations concerning the attitude of those particular alignments.
Okay, following on that, there was a question by Chad Brinton in terms of the inconsistencies between limiting judgment to the original intent or plain meaning of the law and interpretation based on outside factors, modern times, morality, traditionally espoused by conservative judges. Does this criticism somehow weakness the validity of past liberal decisions using the same reasoning?
No, I don't think it does. Those decisions may certainly be overturned. It's possible. I mean, Roe v. Wade, and more to the point, Planned Parenthood v. Casey, which is really the operative decision today. Roe is basically not a significant factor anymore. Those cases could be overruled. And if they are, then states will be free. Remember, that's all those cases say. They don't confer a right to abortion. All they do is they say that states may not constitutionally prohibit abortion. That's rather a different thing. But if those cases are overruled, then states can go ahead and do exactly that. And some states have already adopted legislation. It's already been signed into law that has kind of a fuse attached to it, a lit fuse that says this law shall, most laws end with a validity provision, right? This law will become effective on the day of signing, or the first day of the next fiscal year, or whatever. These statutes all say this statute will become effective the day after Roe v. Wade is overruled. And they're out there. And presumably if Roe v. Wade and Planned Parenthood and the other cases are overruled, then states will go forward and do what they wish to do. Justice Scalia used to say all the time, with respect to abortion, with respect to gay rights, with gay marriage in particular, he used to say, I'm not opposed to these things. Or if I am, that's my personal view. It's got nothing to do with it. My opinions are based on the idea that there is no constitutional basis for making the claim that gay people should have the right to marry, or that a woman should have a right to terminate her pregnancy. I'm not opposed, or at least if I am, I'm going to tell you that. It's a constitutional argument. So the interpretation of the Constitution changes. In 1890, whatever it was, in Plessy v. Ferguson, 1894, I think, the Supreme Court said that it was acceptable for the state of Louisiana to maintain separate railway carriages for black and white passengers because separate but equal was not constitutionally repugnant. And indeed, as the court went out of its way to say in that case, if black people consider the separation to be a badge of inferiority, that's their problem. We didn't impose that on them, etc. And in 1954, the Supreme Court said, oh, come on, this is the 20th century. Separation by race is intolerable, and the notion of separate but equal, said the 9 unanimous justices of the court in 1954, this forced separation of the races is inherently unequal. So, yeah, the court changes its mind. The Constitution is not a fixed target. Oh, one other point to make about that. The Constitution in many places is very, very specific, right? For example, in setting out how the Electoral College is structured, very lays out exactly what all those steps are. But in other places, the drafters used very open textured language, equal protection of the laws, due process of law, cruel and unusual punishment, excessive bail. These terms were adopted deliberately, and we have to assume that they were adopted deliberately by men aware of the fact that the norms, the mores surrounding society are going to change over time. They must have known that what was acceptable as a form of judicial punishment in 1789 might not be acceptable in 1989. And the Supreme Court, generally speaking, has never shied from that. The Supreme Court has said, well, look, we have to decide what is equal protection today. We have to decide what is cruel and unusual punishment today. It doesn't matter that stocks or whipping or depriving of food would have been acceptable as a way of treating prisoners in the 18th century. We have to decide whether it's cruel and unusual applying today's standards. And because of that notion, and Justice Scalia used to object strongly to the use of the term living constitution, but because we do have a living constitution, that's the one we were bequeathed, then there will always be changes. There'll always be changing interpretations, and that's not necessarily a bad thing.
Okay, we have 10 minutes and a number of questions, so put on your running shoes.
Okay. Well, I do have some concluding things I want to say too. So,
and take that into account. You have 60
okay.
people who are still riveted here.
Great.
So a quick, so we have 2 questions on DACA. And I expected students would have something to ask about that. I have, I just want to insert, just if you could, a couple of words on the McGirt versus Oklahoma case on the Native American Indians. Then there is a very interesting question, which could be probably a short response, but why is it that Scientology is also regarded as a religion? If you could comment on that. And from one of our colleagues, which I expect we all have questions about, is do you find it unusual or interesting that there were no international issues of significance raised this term?
Yeah, okay.
I would, can you do this?
I can try.
Plus,
right, so the last one first, no international issues. Well, there was one. It wasn't a big case, but it was a case of some significance. It was the case of the cross-border shooting, the case in which a U.S. border agent standing right by the U.S.-Mexican border saw some kids, some teenagers who were misbehaving, fired a shot in their direction and ended up hitting and killing a young man on the Mexican side of the border. Suit was brought in the United States, and the Supreme Court affirmed the dismissal of that suit on the grounds that there was no constitutional violation because a person standing 6 feet on the other side of the border has no constitutional rights. So that was, that was the international case this term. Scientology.
Marshall Weiss, by the way.
The court has regularly said, I think it's a good thing that it has regularly said, it will not engage in any kind of analysis of the doctrinal content of something that claims to be a religion, as long as it meets criteria that mainly focus on the sincerity of the belief of adherents. It will not examine more than that. The court, once upon a time, used to insist that to be a religion, something had to include belief in a supreme being. That's no longer the law. The Supreme Court has said so. The Supreme Court has said we can certainly have religious dogmas that do not involve a God or anything like that. So Scientology passes muster. Would it, and the only way to challenge it, now that it's been so well established, would be to make the argument that somehow it is something else. It isn't really a church, it's a racketeering enterprise, or it's a Ponzi scheme, or whatever. But those would have to be based not on doctrine, but on operations. What were the others? Or the Indian nation. I got to pass on that. I'm just not. Oh, Daca. Right, let me distract attention from the fact that I don't know anything about the Indian case by talking about Daca. The Daca case, to which the questioner refers, is called the Department of Homeland Security against Regents of the University of California. And in it, the Trump administration attempted by administrative regulation to annul the provisions of Daca by which the executive branch would refrain from prosecuting certain kinds of undocumented individuals who qualified as quote unquote dreamers under Daca. The administration did it wrong. They got it wrong under the Administrative Procedure Act, which is a statute that is generally applicable to the executive branch and requires that before regulations of general applicability be adopted, there has to be a publication of a proposal. The public has to be given the opportunity for notice and comment. Then there has to be deliberation, and then the agency may proceed with its publication. The administration didn't do that. I might say somewhat typically of this administration, it didn't do that. but attempted to argue that this was not a regulation of general applicability. And all that the president was doing was announcing that he was going to prosecute lawbreakers. And he always has the right as the chief executive officer to do that. The court by 5-4 rejected that argument, but in an opinion by Chief Justice by Chief Justice Roberts, yes, and held that as adopted, the regulation was improper, but that if the administration wants to go back to the drawing board, it can try again. There's no constitutional issue. Only Justice Sotomayor dissented on that point. She said there is an equal protection problem here which cannot be remedied no matter what administrative process is used, and that problem will inhere in any reformation of the regulation, and therefore it's unconstitutional on its face. Did I get them all? Except
yeah, you don't have to do the Indian one. Before you conclude, just an interesting question is, as an experienced court watcher, at what point did you feel that this year's term was going to be unusually eventful?
Oh, at the beginning of the term. At the beginning of the term, it was clear that all of these cases were going, well, except the subpoena cases, which of course came up later on. But the Daca challenge, I haven't mentioned at all the faithless electors challenge. That's a big case, a big decision. The religion cases, the abortion case, everybody knew. And in fact, on that one, remember, that case went 5-4 with Chief Justice Roberts in the majority. And I asked the question rhetorically earlier, why did the court take this case in the first place? I mean, obviously it was only because of the retirement of Justice Kennedy. Well, remember, it takes only 4 votes to grant certiorari, not 5. Yeah. And so the 4 conservatives, maybe even unsure about what Chief Justice Roberts was going to do, were willing to take this on. But in any event, that was going to be a blockbuster. There's no question about that. I'm not sure what we have coming down the pike for next term. I'd be surprised if it were quite as far-reaching as this term, but we may get more from the Trump financial records. That may come back. I wouldn't at all be surprised. We may finally get some more death penalty jurisprudence on whether the death penalty is consistent with the 8th Amendment. As a death penalty advocate, I certainly hope we don't, because I don't think that will go well, but that's neither here nor there. We will probably get more immigration.
And we hope that Ginsburg also, we don't know what's happening there, and very much, prayerful of that. There's a wonderful question I want to slip in right before you wrap up, because is there a feeling at SCOTUS that the Trump administration represents a threat to the rule of law? Will any pending cases give the court an opportunity to draw a line in the sand?
Well, yeah, I think so. How about saying, for example, not even the president is categorically above the common duty to prevent. I mean, we've had this. The court has drawn the line in the sand. The problem here is that the line was drawn in a very abstract area. Whether there will be a decision, well, there's not going to be a decision saying the president can be prosecuted while he's in office. I mean, that's impossible. And assuming that the end of his term, please God, will be January, there's no conceivable way that a case could come before the court that would raise that issue in time. That's off the table. Are there other ways in which the court can slap the president down? Look, an absurdly high percentage of judicial challenges to Trump administration administrative rulemakings have been upheld. That is, rulemakings are being thrown out right, left, and center in the environmental area, in immigration, obviously, with respect to law enforcement, and all kinds of places all across this great nation of ours. Judges at the district court level and even at the courts of appeals are issuing nationwide injunctions against the enforcement of these kinds of overreaching. So is it going to be banner headlines on the front page of the New York Times? Probably not, but there will be, and there has been, a constant judicial drumbeat of undermining some of the more excessive claims of this administration.
You've got 1 minute.
Okay. Well, I just want to conclude by pointing out again how significant this term was in all of the areas that I have attempted to discuss. I think the decision in Bostock is, to me at least, a very helpful sign. I have some concerns about decisions in the other cases that I discussed. I recognize that to some listeners, there may be a little bit of a deck chairs on the Titanic aspect to this conversation, because we're facing challenges of really extraordinary magnitude. And perhaps a friend or more than one from Portland is watching this. The city of Portland now appears to be under federal occupation. The city of Chicago may be under federal occupation starting this weekend. We are suffering all kinds of economic crises. The administration seems committed to undermining the Constitution in numerous ways. And the courts have been vigilant, I think, at trying to prevent that. Just the other day, the DC Circuit Court of Appeals would not allow the new head of the Voice of America to gut that journalistic service. So the battles are being fought, and I dare say, and maybe this is the key takeaway, that despite the dissatisfaction and the frustration and irritation that sometimes we feel in the Supreme Court, it's our bulwark. It's all we have. If the Supreme Court, or if the courts across this country do not do what the courts have been doing in this case law that I've described to you, then there is really nothing protecting us against fates that have nothing to do with the Constitution that was left to us by our founders 240 years ago. So thank you all, and I hope I've provoked thought.
I think you have, Professor Schneebaum. I think the importance of these judicial appointments is critical, and you've certainly shown it. We're basically hanging by a thread here, and that's terrifying. Also shows the importance of a lot of lawyers who are protecting our rights here, working very hard. And I would close this by saying, if you see the importance of these decisions, I hope everyone here is registered to vote and will vote.
Hear, hear. Thank you for saying that.
So, thank you. We've gone 2 minutes over, but I think it was
well, thank you. Thanks to everyone for participating in this. And Nina, thank you very much for hosting.
You're welcome. Okay. Goodbye, everybody.
Bye-bye.